Hi, everyone. I'm Frank LoMonte. I'm a journalism professor and an attorney down at the University of Florida in Gainesville, where I teach in the College of Journalism and Communications and run the Brechner Center for Freedom of Information. The Brechner Center is a think tank about the rights of journalists and the public to get access to civically important information. And some of what I'll talk about today will focus on some research we've done at the Brechner Center and on the laws that will entitle you, hopefully, to get access to the information that you need as a journalist to do your watchdog duties. I'm really disappointed not to be in Cambridge, Massachusetts right now, talking to you in the beautiful Nieman Foundation building. I've enjoyed being a guest of the Georges Conference several times in person, but I understand that it's not a great time to ask people to get on airplanes, so we'll do the best we can, and I'll furnish my contact information for anyone who would like to follow up either with me or with my former employer, the Student Press Law Center, which is a wonderful source of free legal assistance and guidance, and even if you needed pro bono representation, if you get into a legal problem that you can't deal with or diagnose yourself. So let's get started. I'm going to show you the obligatory PowerPoint slides, and then we'll share some information and hopefully leave some opportunity for you to follow up with me with questions. So this is my contact information at the university. The Brechner Center is a research center that publishes reports and studies of various kinds you can find on the Brechner.org website that all have to do something with the public's ability to get access to information, including a big focus of our work, which we'll talk about, is the ability to get access to people. The ability to get interviews with the people that you need as a journalist. The first issue, I want to sort of run down the types of issues that frequently result in people calling the Student Press Law Center legal hotline for help. And as we'll see, some of those issues are purely legal issues and they're answerable by a legal answer, and then some of them involve ethical and professional judgments and newsroom policies and standards. And hopefully SPLC and I can provide you some guidance there as well. This is a biggie on college campuses. It's something that we're increasingly seeing as protests erupt around the country involving police violence and racial justice. That brings journalists sometimes into direct confrontations with law enforcement officers. I want to help you try to finesse your way out of those confrontations and understand your legal rights and how to intelligently assert them. And so for starters, it's important to know that you have no legal duty whatsoever to refrain from taking pictures of people or shooting video of people when they are doing things in a publicly visible place. And a publicly visible place is understood broadly to mean basically any place that is not a confined space where somebody would have what's called a reasonable expectation of privacy. I kind of use the rule of thumb that any place you would be comfortable changing your clothes is a place that you have a reasonable expectation of privacy. So in that space, a photojournalist or a videographer would definitely need permission before shooting and could be liable for invasion of privacy if they did shoot. So we're talking about a narrow handful of places that you would never shoot in anyway. You would never go into a locker room in a gymnasium where people were changing. You'd never barge into somebody's hospital room uninvited or sneak into somebody's dorm room and start shooting in their bedroom without their consent. So all of those places that your common sense would tell you that a person has a reasonable expectation of privacy are off limits for photojournalism and videography without consent. Obviously, with consent, you're invited to interview the person while they're in their hospital bed, then go to it. But without consent, those narrowly confined places would be regarded as invasive of privacy. But there's a lot of myths surrounding privacy, and people kind of have a real proprietary sense in what they look like and their images and their likenesses. And while it is true, it is definitely true that people have a right to control how their face is used in connection with an advertisement. It is untrue that people have any degree of legal right to control how their likeness is used in connection with a news event. And your common sense tells you this has got to be the law. after all, right, if Bill Cosby is being led out of the federal courthouse in handcuffs, a huge, gigantic national news event, and Bill Cosby yells out, "I refuse consent to be photographed." Obviously, that refusal has no legal force, no legal effect whatsoever. He's making news. He's in a publicly viewable space. And so even though that's a photo he'd prefer not to have seen on the front page, too bad. Once you leave your house, once you expose yourself to being seen by strangers, then you run the risk that you're going to show up in a news photograph. So there's no legal reason that someone could demand to have a photo either not taken or taken down off your website. And by the way, that includes kids. There is no generalized recognition under American law that somehow children have some magical heightened degree of privacy rights, so that if you are taking that photograph, you're a photojournalist or a videographer, you're at an amusement park and you're doing something on the amusement park, or you're just out in the public park and there's kids climbing on the monkey bars and they show up in your photograph, perfectly okay. It might be a nice courtesy not to use the photograph if the parent gets upset and objects. That might be a nice professional policy judgment for you to make, but it is not legally required. There's no children's invisibility law. That is not a thing. And sharing images online carries no greater privacy protection associated with it than printing it in a print publication. Lots of people are very sensitive about their name or their likeness showing up online, but there's not, in US law, a generalized right to control how you are depicted online or whether you are identified on a website. And this also includes things like a medical emergency that you might be dispatched to. There's quite a lot of mythology out there, and we've really seen this come to the fore with coverage of coronavirus, things like photography or videography outside of a site where people are lining up to be vaccinated, or outside of a site where people are lining up to be tested. And the answer to that question is simply that medical privacy laws are binding only on medical providers and medical insurers. You will often get, quote unquote, the HIPAA answer when someone is being photographed or video is shot and they're entering a testing site or exiting a testing site or entering a vaccination site or exiting a vaccination site. And the answer is, when you take the risk of being seen by strangers, you take the risk of showing up in a news photo. Now, again, it might be a nice courtesy, might be a nice policy decision to agree not to use the photo of somebody who objects, but it is not compulsory legally for you to do so. And there's a reason I have this particular Reuters news photograph reproduced here. This is an amazingly powerful photograph from 2016. It was shot in Baton Rouge, Louisiana, by a news photographer right after the Alton Sterling police shooting, which drew protesters down to Baton Rouge and around the country, including this woman who was actually came down from Pennsylvania to engage in peaceful protest, protesting the use of police force. And this photograph, I think you'll agree, is just a visually arresting photograph. And one of the reasons that it is a visually arresting photograph is that we can see the face of the woman in the photograph. You can see that she has this peaceful look on her face, this look of tranquility as she is being faced down by this overwhelming force of heavily armed people in their body armor. And yet she looks angelic. She looks beatific in this moment, not at all confrontational, not at all angry, just absolutely at peace. And I want you could envision if the photojournalist had decided that, well, I guess we're going to put a big black rectangle over this person's face because they didn't consent to be photographed. History would have lost a really valuable piece of visual evidence of this protest. History would have lost something really valuable here. And so while there are people who are sensitive to being photographed when they are protesting, and certainly you can make the ethical judgment not to take that photo or not to use that photo, consider that there are some offsetting considerations there. And while people may not like being photographed or may not like being depicted, if they've joined in a protest, and particularly if they're, standing standing on the stage at a rally and they're identifying themselves to the crowd, that they've certainly waived any reasonable expectation of legal privacy. And so we should be, as journalists, we should be circumspect about, do we erase history? Do we obscure history? Do we put that black rectangle and change history? Because a black rectangle in a photograph like this one really might have conveyed a misleading impression. If the facial expression of this protester isn't visible, then she might have been screaming at the police. She might have been shouting at the police, right? She might have been angry in her appearance toward the police, but in fact, she's tranquil. And that tranquility is what makes the photograph. So do think carefully about what is being given up and what is being gained if you adopt the policy that says we're not going to take photographs of people who are protesting or demonstrating. But certainly no legal degree of consent, no sign-up form, no release form is needed to take a picture of a newsworthy event. That being said, no right to trespass, no right to block traffic, no right to do anything as a journalist that you couldn't do as a pedestrian. And so it is entirely possible to get arrested and go to jail. I've had to get several college journalists out of jail over the years. If you do something like, set your tripod up in an intersection because that's the best place to get your shot. Well, that's also illegal. You may be obstructing traffic. And so you do not get a free pass to violate the laws that apply to everybody else just because you have a press pass on. So keep that in mind, because often journalists do get swept up in that dragnet by the police. You blend in with the protesters. And frankly, for a college student, that's doubly true because you look young, you look like the protesters. And so think about, make sure you're wearing the most visible press ID that you can. Think about maybe doing some outreach to the officers who are in charge of the scene, if it's possible for you to speak to them in advance. Hey, buddy, heads up, FYI, I'm shooting here. I'm not part of the protest. I'm not a demonstrator. Give me some idea of your boundaries, your guardrails. Is there a particular place that you don't want us standing? We're going to be underfoot or be in your way. Try as best you can to get yourself in a safe legal position to plant your feet. And if you're in a position where it's legal for you to plant your feet, then it's legal for you to gather news. Oh, this is one of my favorite laws that you should absolutely know about, because honestly, many lawyers, many police officers, many prosecutors do not know about it. It's a terrific tool, it's powerful, and we know that it works for college journalists because it's been tried. The Privacy Protection Act was passed specifically in reaction to an overzealous search of a college newsroom, the Stanford Daily. And Congress, alarmed by the fact that police raided the Stanford Daily to try to confiscate their cameras and look at their unpublished photos so they could arrest people who had engaged in a demonstration on campus that resulted in some property damage, Congress passes the Privacy Protection Act, saying that it is illegal for government officials, and it does say government officials, not just police, to search anywhere that journalists store their unpublished work, unless they give you a court hearing where you get to show up, have legal counsel, and assert the reporter's privilege that might apply to your work. Now, this is different from you, me, and Joe Citizen, right? If Joe Citizen gets served with a search warrant and the police show up at the door and say, I'm coming into your home, I'm coming into your workplace, I'm popping open the trunk of your car, the answer has to be, yes, officer, whatever you say, officer, I'm complying because a judge has signed this warrant. So a judge can sign a warrant for a normal search without the person who's the target of the search ever knowing about it. And in fact, that's kind of the point. You don't want to alert or tip off the target of the search that you're on the way. But journalists get this special degree of protection because federal law recognizes that we all benefit when journalists can protect their confidences. And every state has recognized, either through a statute or through a court decision, some degree of reporter's privilege for you to be able to protect your unpublished work. And the reporter's privilege doesn't do any good if the police could just show up, kick your door in, grab all your cameras and all your laptops and walk out the door with them, right? And so the Privacy Protection Act is what makes it possible for these state reporter privilege statutes to work effectively. So do know that this exists. I've used it several times, one time at a college in Virginia, one time at a college in Indiana, to help journalists get their confiscated computers and cameras back from the police. And you can actually sue for money damages. It's a powerful statute. It really works, but know that you have that heightened degree of protection. It is also, by the way, not for nothing, a violation of the First Amendment. If the police were to grab your camera, grab your smartphone, and delete the images out of it, or order you to do so under compulsion of arrest, police agencies have been forced to pay large damage awards or settlements to journalists whose work has been destroyed in that way, because the First Amendment protects your right to gather news if your feet are planted in a place where it's legal for you to be standing. And if the police just kind of appoint themselves judge and jury and decide that they don't like the fact that you've been gathering news there, you're going to destroy your work product, that is established and recognized by the courts as a violation of the First Amendment. So know that you have that right. Now, practical tip here. I always say, don't get into a constitutional law argument with a guy who's pointing a gun at you or dangling handcuffs in front of your face, because you're going to lose that argument every time. Do not ever forcibly resist an officer. The officer starts tugging on your camera, tugging on your laptop, tugging on your smartphone. At that point, you go limp, you let it go, you don't resist. Even if you think you have a legal right to keep that, time to argue that is later in court in front of a judge. Best tip I can give you for any kind of an event like that: you go to a protest, a demonstration, a march, you have a fair idea that there may be some tension between demonstrators and police and that you may find yourself in the middle of that. Be forewarned. Make sure you have the contact information, including home contact information for all your editors, either memorized or in that smartphone or both. And the minute that it looks like you're about to get into one of those confrontations and the police are going to face you down, try to take your stuff away, try to stop you from gathering news, think about getting that editor on the speakerphone. Better for the editor to be making the argument to the police than you. The editor is a safe distance away. That person's not going to jail. So the other reason to get that editor on the speakerphone is if the police do start taking you in, if the police start taking you into custody, you want to narrate your own arrest. You want to tell the officer, hey, the Atlanta Police Department, the Fulton County Sheriff's Department are now putting me in handcuffs, being taken away by the sheriff's department or by the city police department, because then they'll know where to look for you. Because the minute you get to jail, your smartphone is going into the evidence room. You're not going to see that for a long time, and it may be quite a while before you can call for help. All right, switching gears, let's talk about another subject that generates a lot of calls to the Student Press Law Center hotline. And this is something, frankly, that has become more and more prevalent as people start to get reputation sensitive because of the long tail of the Google search, and because more and more news organizations are archiving their old material in ways that makes it easily searchable. And so it used to be that a news story that was unfavorable or unflattering had a very short shelf life. You know, it lasted for about a week, and then that newspaper went into the litter box or into the bottom of the bird cage, never to be seen again. And even though it was possible for somebody to go maybe fish it out, a microfiche at the public library, nobody ever did that. And so these news articles kind of came and went, and people either complained right away or not at all. But that's not the world we live in anymore. We live in Google's world. And because we live in Google's world, you know this very well. Your newsroom has probably already had one or more of these demands, sometimes even comes from a law firm saying, I'm insisting that you take this archival content off of your website, even though it's been there potentially for years, but it's just started bothering me now. You know, I'm applying for jobs, I'm getting engaged, I'm going through some kind of a background check for a sensitive government position, and I want to clean my reputation up online, and I want your story de-archived. Well, the law is very clear here. If something wasn't libelous at the time it was published, it doesn't suddenly magically become libelous just because it's now bothersome. And so even though maybe the person didn't care too much that they, won first prize in the beer chugging competition when they were in a fraternity when they were 20 years old, now they're starting to be bothered by it because they're applying for a federal job and they're afraid this is going to look like they had an underage drinking problem, and so they want their reputation to be cleansed. The answer is, if it wasn't false at the time, it doesn't become defamatory just because it is bothersome years later. Frankly, even if it was defamatory, there's every chance that it is no longer legally actionable because the turnaround time to file a lawsuit is quite short under US law. Most states have a 1 or a 2 year statute of limitations from the time an article is published until it could be sued on. Very small handful have 3, but most have 1 or 2 years. And so if that article was in your newspaper in 1999 or 1998 and somebody's calling now to say, I want it down out of the archives, the answer is, should have complained at the time if you thought it was libelous, but it's certainly not actionable now. Now, just because something's not legally actionable, does that mean it's always right to leave it up? Maybe not. And news organizations are starting to revisit this and rethink this and adopting policies called, like the Boston Globe's Fresh Start policy that they recently announced, that they will allow people to basically petition to have stories about them taken down out of the archives if they feel like they've been in some way unfairly tainted by the long tail of Google. Maybe it's a crime somebody was accused of, but they were ultimately acquitted or never adjudicated guilty of the crime, and they feel like people are jumping to the conclusion by the story about their arrest that they must have been guilty. That's a common type of a scenario where people will pick up the phone or send an email or even sometimes send you a lawyer letter demanding that something be taken down. Just dealt with that recently. There's a situation up at a university up in Washington where some big donors got reputation sensitive because they had just made a huge gift to the university to have a building named after them, and they realized that the fact that they had a guilt adjudication for tax fraud on their record was coming back up in the college newspaper's archives when you search for their names, and they got a lawyer to ask that the article be removed from the archive so that they could have a reboot on their reputations. And the newspaper in that case decided, well, no, tax fraud is a pretty serious thing, and this wasn't some youthful indiscretion. This is something that people did when they were sophisticated adult business people, and that's not coming down. And there are times when your heart may tug in the direction of pulling down an article, and nothing wrong with that if you decide to kind of make a mercy judgment. But the one caution I'll have for you is when you are crafting a policy, and if you decide to publish one online, like a Fresh Start policy, just be careful that you don't come across sounding like you're promising or guaranteeing something. It's the only way that you could possibly create a legal problem for yourself is to hold something out in a way that makes it look like it's a guarantee, right? If you present to us information showing that you were never found guilty of the crime, we will take the story down. Right? That sounds like a promise. That sounds absolute. We will take the story down. And you may want to leave yourself some elbow room to make a judgment call. You know, I don't know how many of you became aware of this, followed this during the Trump administration, but Stephen Miller, the very controversial and polarizing aide in the Trump administration who was responsible for immigration policy, Stephen Miller was a very outspoken newspaper columnist when he was an undergraduate at Duke University. And the ability of researchers to go back and pull up those years-old newspaper columns by Stephen Miller helped enrich personality profiles of him. It helped enrich our understanding of who he was and what he believed. He wasn't a person that gave a lot of interviews or a lot of access to the news media, and so they had to go back and do their own homework or do their own research, kind of fill in the blanks and figure out who is this guy who's so influential and so powerful in the administration, and piecing his personal history together by looking at some of his past archival writings was very helpful in doing that. So, you know, always have that in the back of your mind as well. It's possible that somebody might not be that important or might not be that influential now, but those could be very important tools for journalists or researchers in the future. So just be circumspect about making that unpublished decision. Well, this is my personal favorite topic because it's one that the Brechner Center has published quite a lot of research on in the last few years since I got here. And it's one that I feel strongly that journalists at all levels, students as well as professionals, should be pushing back on. When I got to the Brechner Center, left the SPLC for this job, I asked my journalist friends, both at the college level and the professional level, what are your pain points? What are the things that are most getting between you and the news? And overwhelmingly, this is what people told me. Nobody on the beat that I cover is allowed to talk to me. Everybody is under the impression that they've got to get permission to speak to the news media. We have this very heavy-handed gatekeeping by the public relations office at this agency or at this university that never lets me get access to the frontline people that actually have the firsthand information. And I wound up having to publish some canned response with made up quotes by a public relations person who wasn't really on the scene of the news. And that's frustrating. It's frustrating, and not only frustrating to you, but it cheats your readers. When you're writing that story about the COVID pandemic, you need the voices of those doctors, those nurses, those first responders who've actually been there on the front lines fighting the pandemic. You don't need a canned statement from a hospital PIO. You want to actually hear and see and feel what those people have been going through when they've been pulling those 16-hour shifts in the emergency room. You don't need a prepared statement. And in order to do that, you've got to be able to have unmediated conversations with the newsmakers on your beat. Is there a legal way around these gag orders? The answer, surprisingly, is yes, that there is. There is an overwhelming body of First Amendment legal precedent that we know that government agencies and their lawyers are widely unaware of, an overwhelming body of legal precedent saying that government agencies, and it includes a public college or university, cannot enforce one of these blanket prohibitions on speaking to the news media. So if your institution has a policy like everybody here must get authorization from the Public Information Office before speaking, or no interviews will be allowed, you must refer all media calls to the Public Information Officer and not answer any questions, all of those things violate the First Amendment rights of the employees. We even think that it is possible for a news organization to initiate the First Amendment lawsuit themselves. They do this all the time in the context of gag orders that judges impose on witnesses and parties in trials. When there's a high-profile trial, it's common for a judge to impose a gag order telling everybody don't talk to the media, and then news organizations will get counsel and they'll challenge the gag order, and they usually win. And so there's a roadmap for doing this. There's precedent for doing this. And so if you are at one of those agencies, be aware that you may have legal recourse and publicize the illegality. Write about, publicize the fact that your organization is enforcing a policy that violates the First Amendment rights of its employees. Now, we know the First Amendment only works at public institutions. It only works at a state or a college or university because the First Amendment protects you only against the government. And Duke University or Northwestern or Harvard are private actors. Is there any recourse there? Yes, surprisingly, there is. The National Labor Relations Act gives employees rights that are somewhat comparable to the rights that are guaranteed in the public workplace by the First Amendment. And the National Labor Relations Board, which enforces the NLRA, has ruled over and over and over again over the past several decades consistently that an employer, even in the private sector, cannot enforce a blanket gag policy that says no one here is allowed to talk to the media, no one here is allowed to discuss any work-related matters with the press or public. Those types of policies are routinely struck down as unfair labor practices under the NLRA. And the NLRA does apply to higher ed institutions. It doesn't apply to little mom and pop stores, so that neighborhood deli is not governed by it, somebody that's just doing a purely local business in your community. But universities and colleges are plenty big enough to be governed by the NLRB. Also, it doesn't apply to an overtly religious institution. So an institution like a Liberty University, which exists as a faith-based institution to teach biblical principles schools. They're probably not governed by the NLRA, but just the fact that your institution might have been founded by a church or affiliated at one time with a religious order does not mean that it's not covered. It would have to be an overtly religious institution where the primary purpose of the institution is to teach religion. And so something like Duke University, which was at one time started by a religious order, is certainly governed by the NLRA. So you should know that employees on your campuses have a right to speak to the news media without being told that they'll be punished if they do so. And when you run into one of those unlawful gag orders, you should absolutely challenge it, question it, and publicize it. Now let's talk some about access to public records. And I know that a lot of people watching and listening are at private institutions, and you've probably experienced the frustration of trying to request public records, and you come to find out that your State Open Records Act or the federal FOIA only apply to government agencies, i.e. state colleges and universities. We'll talk in the wrap up about some laws that also apply in the private sector that may give you some entitlement to documents about your institution. But for now, for those of you who are dealing with public institutions, you should know that the FERPA federal privacy law is often misstated as a grounds for withholding public records. And in fact, there's much less to FERPA privacy than meets the eye. This is a frequent complaint that journalists at all levels, college as well as professional, have about their interaction with any educational institution, K-12 or college. Everything you want is purportedly covered by FERPA student privacy. Here's the reality. FERPA, the Family Educational Rights and Privacy Act, is a pretty narrow law. The way that it's been interpreted by the Supreme Court is that it applies only to that subset of records that would be regarded as centrally maintained education records that identify particular students. Centrally maintained education records that apply to particular identifiable students. The kind of record that you would be given if you showed up at the dean's office or the registrar's office and you said, I'm here to review my file. What would you be given? Probably your standardized test scores, your transcripts, maybe some minor disciplinary scraps you've gotten into, and that's probably about it. You would not be given a stack of every email that's ever been sent by any employee at the institution in which you're referenced. You would not be shown a bunch of surveillance video or security video where your face shows up. So colleges know very well what FERPA covers when a person shows up to assert their right under FERPA to inspect their own records. They know that it is a narrow law. But when a journalist shows up asking to see public records, somehow it magically expands to become what the courts have kind of derisively referred to as an invisibility cloak. Well, we just got a reminder this year from the Kentucky Supreme Court in the long-running Kentucky Colonel case that FERPA is not an invisibility cloak, that people do not turn invisible just because they enroll in college. In the Kentucky Colonel case, the student newspaper, they're sued for access to records showing how employees were punished or not punished when they were found responsible for having committed sexual harassment, in particular sexual harassment directed at students. When the University of Kentucky was presented with that public records request, they presented the FERPA objection back. We can't give you anything out of these files. We can't give you our files on who we've punished and how we've punished, because we think that it might somehow enable Sherlock Holmes to reverse engineer the names of the students who were the victims, even though the newspaper explicitly said, we agree to take these with all victim and complainant and witness information redacted out of them. All we want to know is, did you adequately punish the employees who were found responsible for sexual harassment? University of Kentucky fought this for 5 years, but just this year, the Kentucky Supreme Court weighed in and sided with the Colonel and said, these are public records, and FERPA is not an excuse for the blanket withholding of all the files. Yes, the university can go back, and yes, they can de-identify the record by removing student identifiers, but the balance of that document is a public record and has to be produced. Great reminder that public records laws in general are not an all or nothing proposition. If it is possible to remove the exempt material, the confidential material out of a public record and produce the balance of the document, then agencies are required by law to do so. So if you make a public records request and you get back an empty set, you get back a big nothing, everything you want is confidential, there's every chance that you're entitled to at least a halfway production of the redacted portions of the document. So always push back against those blanket denials under your Public Records Act. We know, by the way, because this has been tested in court or it's been memorialized in U.S. Department of Education interpretations, that FERPA does not apply to things like the outcomes of serious campus disciplinary cases where somebody is found liable for committing what equates to a crime. This was also recently litigated to a successful conclusion by the student newspaper at the University of North Carolina, which in 2020 got a long-awaited judgment back from the North Carolina Supreme Court saying, yes, the Public Records Act applies to these final disciplinary outcomes when the Student Conduct Board completes their work and concludes that Joe's student committed a crime of violence or a sex crime. And so you're entitled to have those outcomes, including, by the way, the name of the person and what penalty they received. And these have been quite important records for college journalists to get because they shed light on the fact that very frequently you find, as is the case of UNC, that almost nobody is getting found liable for sexual assault. Almost everybody is skating through the disciplinary process in one way or another. And even when they do get disciplined, the discipline is often rather light. Sometimes it's as light as disciplinary probation. There's a compelling public interest in knowing that. So FERPA doesn't apply if the person is found liable. If the person is acquitted, then that remains an exempt record and you probably will never see it. Directory information. This is kind of the who, what, where stuff. At every institution is unprotected by FERPA. And so if a student is found to be involved in a crime, let's say in the community, and you call up the university, you want to know, is this person still an enrolled student or is this person left the university? They cannot invoke FERPA to refuse to tell you that answer. The enrollment status of somebody is regarded as what's called directory information, which the US Department of Ed and the FERPA statute recognize as exempt from FERPA, meaning that it can harmlessly be turned over to you, and it should be turned over to you at a state university. And importantly, the US Department of Ed has said that FERPA applies only to documents and not to facts and information. Let me say that again. FERPA applies to records and not to impressions, information, facts, recollections. And so if you're interviewing somebody and you're asking, coach, when did you find out that the star player on your team was accused of sexual assault? And what did you say? What did you do when you found out about that accusation? The coach cannot cite FERPA and say, I'm forbidden from telling you what I said. I'm forbidden from telling you what I did, because FERPA applies to that centrally maintained education record. And you're not asking the coach to produce that centrally maintained education record. You're asking for personal experiences, observations, and recollections. And that the US Department of Education, which is the authoritative word on FERPA, is not protected by student confidentiality. So that's a bad reason to object to that request. I promised I would give you some resources that work at private as well as public institutions, so let's talk about that. There are some federal disclosure statutes that will actually work at private institutions that will enable you to get some information out of your institution or about your institution. The IRS 990 form, if you haven't already dug into this, if you're at a private institution, your college files one of these forms, unless it's, again, a super church-affiliated institution like a seminary. It's not one of those things, and it almost certainly files an annual tax return with the federal government under IRS Code 990, and that is a public document. You can either search for them on this website, guidestar.org, or frankly, the institution is legally obligated to provide it upon request. So you can get it upon request, or you can find it online at GuideStar. Guide Star. And this is, it is just like a tax return that you and I file every April if you and I happen to have $1 billion in our savings account. It is a snapshot of the finances of your institution, how much money they took in, how much money they spent. Importantly, it has the highest executive salaries and also the highest contracts that they enter into every year. So you want to know how much they're paying that Aramark dining contractor. You want to know how much they paid their law firm because they're in legal trouble a lot. You want to know how much they paid that construction contractor to build the stadium. There's every chance that that dollar amount is going to show up in the IRS 990 report. That's how we know at private institutions, which are subject to the IRS code, that's how we know something like what's the head football coach's salary at Southern Cal or the head basketball coach's salary at Duke. We know that because they're subject to the IRS tax code. They have to make these 990 forms available, including their highest compensated employees. This is also a great tool if you're at a public institution that has nonprofit affiliates, like a privatized athletic association, like a privatized fundraising foundation. If you're a member of an athletic conference, Greek letter organizations, like the national fraternal organizations, those are subject to IRS 990 code because they're incorporated as nonprofits. So just let your imagination run wild. Go on that GuideStar website, do some searching for your institution and for the affiliates of your institution. And I guarantee you'll always get a story out of it. By the way, these tax returns, I'm sorry to say, are very tardy because the IRS tax code is very forgiving of nonprofits. It is keyed to their fiscal year. And so if somebody has the typical fiscal year would end on June the 30th, they're going to have until November to file that IRS 990 report. And so it's a belated snapshot to be sure. And also I should always caution when you're dealing with data. Data is a great starting point for your reporting, but it's not the ending point. You have to always interrogate and validate and verify that data. You know, if you just run to publication with it, you may get misled and you may tell an incomplete story. Now, let's say you pull that 990 report and it shows that the football coach made $2 million this year and $4 million last year. Well, you might jump to the conclusion that they cut the coach's pay. But maybe not. Maybe what happened is the coach left halfway through the year, and so the coach was fully compensated at their rate. Or maybe it turns out that they shifted some of the compensation from the state to the athletic association or vice versa, so it's coming out of a different pocket. So interrogate that data. Use it as a starting point to open the door to get your questions answered, but always be cautious about jumping to conclusions based on data that might look too good to be true or might look like it doesn't make sense to you. If it's not making sense to you, then there's every chance that you're right, that your instinct is right, that it doesn't make sense, and you need to inquire further. Equity in Athletics Disclosure Act. This was passed as sort of an adjunct of the Title IX gender equity statute, which, as we know, one of the many things that Title IX does is it addresses inequities in women's sports versus men's sports. And the Equity in Athletics Disclosure Act is kind of a way of holding institutions responsible for their Title IX duties, that they're supposed to be providing relatively equal athletic participation opportunities for women as for men. And the Equity in Athletics Disclosure Act is kind of your way and the public's way of being able to go back and hold the institution accountable and see if they're really doing a good job. Do they have comparable numbers of people participating in women's sports as men's sports? What are they paying the coaches for those sports? What are they spending on the programs and what are they taking in from those programs? Equity in Athletics Disclosure Act, and there's a great searchable cutting tool on the ed.gov website. Really just Google Equity in Athletics cutting tool, and this will be the first result that comes up. You can put your institution through there. You can also put competing institutions through there to see how you stack up. One of the really interesting things that journalists have been able to do every year by crunching the numbers and doing some math, looking at these Equity in Athletics disclosure reports, is to figure out, are athletics really profitable or not? Spoiler alert, unless you're the Alabama Crimson Tide or the Texas Longhorns or a handful of other big football schools? The answer is probably no. If you're the University of Cincinnati, if you're UConn, the answer is you're probably not making a profit off of athletics. You're probably lucky to be breaking even. And sometimes athletics are propped up and subsidized by grants from things like student activity fees that keep them from showing a loss on paper. But that's a great story. Does our institution actually make money on athletics? Because the popular impression among the general public is that, of course, athletics are cash cow, but it turns out, unless you're one of those big TV contract institutions that sells out the 120,000 seat football stadium, there's every chance you're actually not making very much money at all. Cleric crime reports, probably already familiar with this because institutions have gotten better about actually texting out and emailing out links to these every year when they release them. But this is a classic example of data that badly needs interrogating. Do not take these reports at face value. You've probably already been a skeptical consumer of this data. You get a Cleric annual crime report from your institution. It says there were 2 rapes on campus last year, and your common sense is telling you, wait a second, we have 30,000 people here. No way that the right number is 2, and your common sense is right. These reports are often wrong, and when they're wrong, they're always wrong in the low direction and not the high direction. And you really want to do some sit downs with some folks, ask them about the process by which these things get put together. What is supposed to happen is the institution is supposed to be gathering that data from people all across the campus who have any responsibility whatsoever for safety, which is a very, very broad universe of people. So somebody like an athletic director, like a coach, like a sponsor of a club, those people all are regarded as having safety responsibilities, and they have to make sure that if they find out about a serious crime, that serious crime is showing up in the Clery Act annual crime counts. But oftentimes we find that, in fact, the institutions are only counting the crimes that made it to their campus police department and got investigated as crimes. And we know in particular for sexual assault that the vast majority do not. The vast majority either get funneled through the student conduct process, or maybe they go to an off-campus law enforcement authority like the city police or the county sheriff's office. All those numbers should be getting counted in these statistical reports, and if they're not, then the report is wrong. And so call that out. There's also a tab, if you look at these crime reports, for student disciplinary statistics as well as crime statistics. And almost no journalists ever write about that. They stop at the tab on the report for crime, which is the headline thing that's the most sexy and interesting, and they stop there and they don't look at the disciplinary stats. But look at those disciplinary stats. Sometimes they are absolutely wacky. You will see numbers fluctuate wildly for no apparent reason. There were 300 disciplinary cases for drugs last year and 25 this year. You will see crazy fluctuations like that. And again, you want to interrogate that data, find out, did you change your policies somehow? Did you decide that you're going to stop sending these drug crimes to the disciplinary board? Did you change the disciplinary standards? Did you decide you're going to start prosecuting them as crimes? You want to really, really get to the bottom of data that either looks too good to be true or just looks wacky. That's a story for you for sure. So dig into those crime reports, interrogate the data, and consult with outside experts, people like Dan Carter, who's a campus security consultant, is great on this stuff. Run this by outside experts, what the university is supposed to be doing on their crime report versus what they're really doing. And by the way, this applies to any institution, public or private, that takes even a nickel of taxpayer money, and they all do. They're all taking at least some Pell Grants or some degree of federal financial aid. So don't be fooled. You're at a private institution. This applies to you as well. I want to do a little bit of a plug here, not very much, but just a shout out to this podcast that my friend and colleague Sarah Ganem, who's a Pulitzer Prize winning reporter, she's the person who broke open the Jerry Sandusky sex abuse scandal at Penn State. Sarah is now working with me on the podcast called Why Don't We Know? It's online at whydon'tweknow.org or whydon'tweknow.com. And every week in the podcast, there's 13 episodes up online now. Sarah does a different deep dive into another aspect of government secrecy. And we focus the entire first season of the podcast by looking the spotlight inward at education and especially at higher ed. Each episode focuses on a different subject of what we're calling data deserts, places that your common sense would tell you that surely there must be information available or statistics available about X, Y, Z topic. And it turns out that either it's incredibly hard to get, or maybe the institutions aren't even bothering to keep it at all. So there's episodes about things like how often do athletes have concussions? That's our first episode. That's the kind of story where you think to yourself, well, surely in the 21st century, surely with everything we know about concussions, universities must be keeping scrupulous track of these trends so they know, are the concussions getting better, getting worse? Are there safety precautions working? And it turns out not so much. In fact, many of them insist that they don't keep track of these, and even some of those that do will not turn them over. These are the kinds of stories: concussions, hazing, asbestos in campus buildings, safety of rental properties, that are ripe for you to localize in your own community. And we encourage you to do that. And both Sarah and I would happily help you out with, if you get stuck on one of those stories, reach out to us. We're findable on the ufl.edu website, or our contact information is on the Why Don't We Know website as well. Would love to have you follow and share that podcast. By way of wrap up, I do need to give a shout out and a plug to my good friends, Hadar Harris and Mike Keystan and Summer Ingram Dean at the Student Press Law Center. Wonderful staff of attorneys who are on call round the clock to give you free legal help with any question that you have. They've got a network of 250 volunteer lawyers around the country who've agreed to consult with and even take court cases for student journalists if they find that they're in legal representation. So take advantage of the services available at splc.org. Oftentimes you can use those legal guides to diagnose your own problem, and they're great training materials. As an editor, you're going to need to be doing some onboarding for your new staff people. Think about pulling some of those training materials. For example, I mentioned the Privacy Protection Act. There's a guide to the Privacy Protection Act online at splc.org. There's a guide to the Cleric Act online at splc.org. And of course, they've got a free attorney hotline. Drop them a note at the splc@splc.org email. Thanks again for your attention, and thanks again for the public service that you are doing as college journalists. I really mean that sincerely. What you're doing is incredibly important, and increasingly, if you're not doing it, nobody will. These colleges need careful scrutiny, they need careful watching, and we know that community news organizations frequently don't have the staff to do so anymore. So you as college journalists, you're the public's first and sometimes only line of defense to keep watch over these very powerful, well-funded institutions. So you're doing amazing work, you're needed, you're valued, you're appreciated, and get in touch if we can ever help you. Thanks a lot, and enjoy the rest of the Georges Conference.